Welcome to the Center Collaborative, Creative Solutions in Behavioral Health and Criminal Justice, brought to you by the Oregon Center on Behavioral Health and Justice Integration, which is also known as the Center. We at the Center are all about solutions. Our job in Oregon is to facilitate improvement of the system so behavioral health and criminal justice can work better together to engage people in treatment while promoting public safety. I am your host, Chris Thomas. I hold a master's degree in clinical psychology and have focused on the intersection between behavioral health and criminal justice for 20 years. Over 7 of those years were behind the walls of a maximum security prison. During this podcast, you will have the opportunity to sit in on real, in-depth conversations with experts about complex topics in a way that is both fascinating and digestible. We will focus not just on what is wrong with the system, but what is going right and how we can work together to evolve. Today's episode is part 1 of a 2-part series with Judge Suzanne Chanti, Senior Judge, and Judge Nan Waller, Circuit Court Judge. They are co-chairs of the Chief Justice's Behavioral Health Advisory Committee, the BHAC. Judge Chanti and Judge Waller are speaking with us today based upon their own experiences and are not speaking on behalf of OJD. During part 1, we define procedural justice, also known as procedural fairness, and talk about mindfully incorporating procedural fairness within the courtroom and throughout the courthouse. We discuss the importance of slowing down and involving folks within the court process. We talk about trauma-informed processes, cultural competency, being in touch with the humanity and the loss that folks are experiencing within the court process, and also the vicarious trauma that judges and court staff experience. I learned so much during my conversation with Judge Chanti and Judge Waller. I think you will too. Welcome to our conversation. Judge Waller and Judge Chanti, thank you so much for joining me today. This is my pleasure.
Thank you, Chris. Our pleasure too.
Yeah, nice to be here.
So I know that procedural justice is a passion for both of you, and I'm wondering if we could start out with talking about procedural justice versus procedural fairness, so our listeners have an idea of if there's a difference between those two terms and what they mean.
Procedural justice and procedural fairness are really terms for the same concept, and procedural justice is based upon a body of research that really began with Tom Tyler from Yale that looked at what needs to happen for people to have trust, to buy into a system, and then to follow through and act upon directives. And a lot of the research started with the police, but it's also then really focused on the courts. Procedural justice is the perceived fairness of court procedures and interpersonal treatment, and that's contrasted with distributive justice. Do you win or lose? And of course, everyone likes to win. Outcomes matter, but procedural justice theory assumes that people know they can't always win. People will be more likely to accept losing if they perceive the process as being fair and the interpersonal treatment they received respectful. That's, I think, in the arena that we both deal in, it's very important for people to feel like they've had an opportunity to present their side of the story, voice, that's one of the 4 principles of procedural justice, that they're treated with respect, treated with dignity, with engagement on a human level in an understandable way, that there's neutrality, that there's a decision maker who's unbiased, follows the rules and applies the rules consistently, and understanding that they understand what's going on, they understand their rights, they understand the process that is being delivered. And what the research shows is that's actually more important, procedural justice, than whether or not people win or lose in the end, given, of course, that everyone likes to win or get what they want when they're in a court proceeding, but everyone also knows that's not going to happen.
So I think what I'm hearing you say is that if someone feels heard and they're able to truly talk about what's going on with them to someone who they feel is unbiased, that even if they don't like how it turns out in the end, they're much more likely to go along with what happened, whether if they have to go into treatment or anything like that, they're much more likely to engage than if they did not feel that those things were happening. Am I hearing that correctly?
You are hearing that correctly. Even when people lose in court or don't get what they're wanting or have to do something that they hadn't wanted to, they are more likely to accept it and follow through. And obviously, that's imperative to the court functioning. Judges issue orders, make decisions in cases, but in the end, whether people have confidence in those decisions is going to have an impact as to whether or not they'll follow through on the decisions. We much prefer to have people accepting the decisions and following through than having to use the authority of the court to force people to follow through. And so that's the basis for procedural justice being so imperative throughout the justice system. And when you think about it, it's what we all want. We want to understand what's happening. We want to feel like we have the opportunity to tell our story, to be treated with respect, to understand what is occurring, and just think of some interaction that you've had, whether it's some complicated website or you're on the phone trying to get through to somebody to explain the benefits that you're trying to get. Even if we can't get what we want in the end, if we feel like we were treated fairly, we're much happier. There's a lot of research around this. And one of the things that I think is truly amazing is from a 2008 UCLA neuroscience study that said that perceived fairness activates the same brain circuitry as does winning money or eating chocolate.
Oh, wow. That's pretty surprising.
Yeah.
I think the listeners would be interested in knowing there's so much research around this. And procedural fairness, procedural justice is a big conversation right now. It seems to me when we talk about courts and justice, that is the ideal of what one would want in those courts. How is this a different way of looking at things?
It's slowing down enough to explain, give people the opportunity to hear plain language so that people actually understand. When I used to do case assignment, courtroom full of lawyers, defendants, and a big docket. And I found that when I really looked at what I was doing, that oftentimes I was talking to the lawyers, making sure the defendants were there, but talking with the lawyers almost in a legalese code. Probably to some people it sounded like a different language given the numbers of acronyms and all that we were using. And I would watch as defendants would walk out of the courtroom frustrated, sometimes that their case was being set over, balling up the piece of paper that we were giving them that told them the next directions for their case that they needed to follow in order to get to court on time, avoid a warrant. When I start acknowledging every defendant in the room, explaining what was going to be happening, that I was primarily going to be talking to the lawyers, they understood the next step that they needed to go through. And I would have, this would be a felony case assignment docket where people were facing trials on cases that could easily send them to prison for a long time. But just those simple things of acknowledging eye contact, making sure that it was understood, asking if they had any questions, didn't take very long on any one case. But people would leave the courtroom and say, "You have a great day, Your Honor. Thank you." And that little bit of a difference made such an impact on me that I've realized that every time I'm talking to people, explaining how we're doing things at the beginning, and we all get busy and we have busy dockets, and it's sometimes the pressure is on to get through the docket quickly. I don't think procedural justice in the end takes more time because it ends up with people who have better understanding or are likely to be able to make it to the next step of their case in court, not be frustrated or feel like they were left out, or all of the lawyers and judges were talking above them and without them, when really the case is all about them.
That really helps me understand what we're talking about and what the difference is. Really listening to that person, involving them in the conversation and letting them know what the process is, instead of them just feeling like anybody could be standing there and they're being told what to do versus being included in the process.
Absolutely.
So I'd imagine that this is really important with everybody appearing in front of you. I'm wondering if there are certain populations where this is even more important than with others.
I don't think there's a population where it's necessarily more important, but I would say that part of procedural justice also includes, we call it now, trauma-informed responses. So it includes understanding a little bit about the people that are coming in front of you. And sometimes you don't know what the trauma background of the person is, but in some proceedings, you have a pretty good idea. For instance, in a civil commitment proceeding or a proceeding involving aid and assist, which is a proceeding where a judge is determining whether the person is competent to aid and assist in his or her own defense. In those cases where the question is, does the person have or is experiencing a severe mental illness, a lot of times those folks come, and if they are experiencing their illness in the moment, it's important to understand how to slow things down, how to speak with those folks, how to emphasize the portions of procedural fairness that are going to help them be less traumatized by the court proceeding itself, because the court proceedings they're stressful to a lot of people. But in this particular case, it could be even more stressful because the person is also perceiving what's going on through whatever the lens of their psychiatric experience is in the moment.
I think this is a good place to add for our listeners that both Judge Chanti and Judge Waller have experience as treatment court judges, and so are very familiar with specialized dockets working with folks with behavioral health conditions. So as I'm sitting here listening to you chat about procedural fairness and procedural justice, and it's about slowing down and taking the time, I'm wondering, I remember hearing you say earlier, Judge Waller, about folks being concerned about it taking more time to do it this way versus doing it the old way. And I'm wondering if either one of you want to touch on that.
I want to clarify that I'm not sure that it's the old way. I think that procedural justice has been part of the court culture for a number of years, and we all strive to provide it. I think we've learned more from the research about how to achieve it. Just to give you an example, Judge Waller mentioned that it's important that the person before the judge perceives that the judge is neutral and trustworthy, right? The judge is going to listen to the facts and the evidence and then make a decision in a neutral and fair way. And what we've learned from research about that just particular part of procedural justice is that a judge, to make decisions in an unbiased manner, has to actually learn how to suppress their own personal biases and values, and has to learn how to keep those values from skewing their decisions. So there's been training that we've received, and there's research about how to do that. It's not the easiest thing, but it takes a presence of mind, because we all come, judges included, to the table with our own experiences and views. And so that, I think, is what's changed, is there's more of a focus on, okay, here's what it is, but how do we actually achieve it? And so, for instance, looking at personal biases and values, and then consciously suppressing those when you make a decision. That's just one component of what the current effort in the judiciary is. So I think it's been something that's been there for a while, understanding that you have to treat people fairly, with respect, with dignity. But now the research is going behind those things, and not only that this works, but why does it work? Why does it cause people to believe and have more trust in the justice system? And then also, what can judges, but there's other people in the justice system also that provide procedural fairness, including someone like a clerk when someone comes in to file a document or needs some help. So it's a continuum. It's not just judges that provide it, it's the whole judicial system. And if you want to go outside of the judicial system, it's lawyers, and if in criminal context, it's law enforcement. But the research is more focused and getting more developed about exactly how do we achieve those things, like not just slowing down, but for instance, how do you talk with somebody? How do you pay attention to their cultural differences? How do you, so that you're not offending them culturally without knowing that you're doing that? Or how do you explain something to somebody in a way that they can understand it? And that would include people that are experiencing mental illness. It would include people that are having difficulty in court just because of the stress. It would include people that have trouble cognitively processing a bunch of information coming at them at once. So that's, I think, what's different is not the principle or the idea of procedural fairness, but the actual details and the development of the research about how do we achieve it and why are these particular components of procedural justice so important.
I do think, though, it is easy for all of us to fall into not really paying attention to the principles of procedural justice when we're covering a docket, talking to lawyers and a defendant or the parties are there in court. We had a procedural justice assessment done of our court by the Center for Court Improvement a number of years ago. I was impressed and I think concerned for that I would agree with Judge Chanti, that we all believe in procedural justice and understand procedural justice and the importance, but it's easy to slip into that talking in the lingo of court without making sure that the people who are going to be affected, who the decisions are going to make, are really understanding. And so it's important both in terms of the principles of procedural justice, and I would agree that bias and trauma-informed practice are certainly parts of procedural justice, and that for people with mental illness who sometimes the things they are saying may not make, if they're in the middle of a mental health crisis, may not make the most sense, but treating people with respect and not immediately saying, gosh, that doesn't make any sense, helps people calm down enough sometimes so that they can listen. Court is stressful. We want people to be able to listen enough, not have stress so blocking their ability to understand what is occurring, and then to participate. And I think that all of this, that's our goal as judges and as a court system, to make sure that people are engaged and have the opportunity to fully participate and understand. I think that overall increases confidence in the justice system. And in the end, that is absolutely necessary for the work that we do to actually resolve disputes.
That's incredibly helpful clarification, both in the extra training around biases and making sure that judges are doing their own work. And then, Judge Waller, your point too, how easy it is. And it's easy for all of us, right, to revert back to lingo and getting things done in a procedure, especially when you're really busy and you're covering for someone else, how easy that is to do, and just being mindful of that.
We had a presentation yesterday on plain language, which I think ties in very nicely to procedural justice. It is part of procedural justice, and it was amazing the difference in terms of being able to understand something when it was written in plain language, as opposed to, I looked at a lot of our forms, and I know that's a goal of OJD, is to get our forms to a point where they're understandable, which is difficult because we're conveying complex information that has an impact on the next steps of somebody's life. So we want to be legally accurate, but we also want to be understandable and have people be able to truly understand what they have to do and the impact if they don't.
What Judge Waller just said about that reminds me that I'm sure she has the same experience, that over the 30-something years since I became a lawyer, I have seen there's something about the law that is self-serving in the sense of lawyers have exclusive licenses, and the culture that's built up around the various language, the various legal terms of art, they're both tools of the trade, but they're also like part of the cultural club of the law. And what I've seen over the last 10 or 15 years, at least, is a breakdown of that legalese and a breakdown of that separateness of the law from there's the lawyers and the judges, and then there's the litigants, the people that the lawyers and the judges are there to serve. So the people in the earlier days of my law practice, the people would come in, and Judge Waller said they would be talked about, the lawyers and the judges would be talking, and they'd be using all these terms and making all these points that the people couldn't necessarily follow because they weren't supposed to be able to necessarily follow it, because the law has its own language and its own, at that time, more of its own culture even. And I think that there's been a significant breakdown of that. I know that in the judiciary over the last 11 years, 12 years that I've been a judge, I've seen a big focus on our responses to people being more human-centered, more empathetic, more customer-driven, if you will, more service-driven than I experienced when I was a lawyer. And I like that development. I think it's really important. And what Judge Waller just said, it's just evident there. So they've had a training about how to use language in a way that people can understand it. And it's not necessary to use these big, long words that we learned in law school. We could explain the same principles in just basic words. So I'm really optimistic about the changes that have been made over the years. We have a long way to go, but I also think that our judiciary now in Oregon, that I think if you talk to most judges, they would be not only aware of procedural justice, but they would have some desire to actively learn more about it and develop the skills to deliver it. And it's not a natural ability. You have to really think about what you're doing and what you're saying and why you're doing and saying what you're doing and saying. And you have to also, there's a crush of work behind you, and you have to not give in to that crush of work and stay focused on the people that are in front of you in that moment.
I know you all aren't therapists, but that's what it makes me think of, is because that's my background. That piece around not succumbing to the lingo, which is so easy to do, and really being present in the moment with a person and trying to check yourself and where you're at in that conversation, where you're trying to meet someone where they are, and how difficult that is, and how you have to do your own work for that, because it creeps up on you if you don't.
I will tell you, Chris, that I was in a meeting with a number of clinicians the other day, and I was keeping track of all the acronyms and the words that I didn't know what they were talking about. I had no idea. And I was, at the time, I thought, oh, this is exactly what it's like. I'm embarrassed to say, excuse me, stop. I'm not understanding what you're saying. I feel, because of course I felt like I should have enough of an understanding of the topic that I should have understood. And I think that's often what people coming into a court can feel like, that we all may be speaking the same language, but if you're not understanding the words or the terms, you feel very alone and disconnected, and sometimes you're just like you're not up to snuff.
Absolutely. Absolutely. I'm laughing because I think about how often I find myself and my team, how often we go to the land of jargon. We're working on a script right now for a radio play for this podcast around explaining privacy laws in plain language. Yeah, it's been a 2-year thing, taking HIPAA and CFR and trying to translate that. So there'll be a plain spoken translator that explains the legalese. And so we were just working on a section last week, and I'd had a very long day from meeting to meeting. And it was at the very end of the day on a Friday. Brutal. And they're explaining some very complicated topic to me, all in legalese. And I looked at them blankly, and I just was like, yeah, I have no idea what you're talking about. All right, let me just hold back and explain it to me again. And it was all in legalese again. And I was like, okay, just humor me. It's been a long day. And finally I said, do you mean this and this in very plain language? And they said, yeah. And I said, why didn't you just say that then? But I felt like I was definitely not up to snuff in those moments. And I know that happens with all of us in our profession. And it's so easy to do. It's easy for us to do with each other, and how it's easy for us to do that when we talk about any of the statute or the programs we have going on or what would be happening in a courtroom. It's so easy to slip into that.
I absolutely agree.
So I've heard you both talk a bit about training, preparation, and what judges need to learn and think about differently when you're really trying to mindfully incorporate procedural fairness in your courtroom. Can you talk a little bit about what that looks like and what kind of training or how that looks in the courtroom that would be different?
For me, I think different judges probably approach the issue differently. I try, before I go into a court proceeding, and let me just back up a little bit about how it is for some judges. I'm not familiar with all courthouses, but it's typical for me and other judges in my courthouse you get an assignment or a docket. We call it a docket, which is what kind of case it is. It might be a restraining order docket. It might be the criminal plea and sentencing docket. There's just a number of what we call dockets, which is really a cluster of the same types of cases. And so I might start my morning with one docket, say the restraining order docket, where people are coming in who are seeking restraining orders because they've been victims of domestic violence or elder abuse, or they're seeking a stalking order. And so they come in, and before COVID, it would be in the courthouse. Now they submit their paperwork, and then I talk to them through the computer or on the phone. So you do that docket, and then you go to a hearing that you've been assigned. And that hearing may be a domestic relations custody case. It may be a trial in a civil case. It may be a criminal trial. And again, different judges in different courthouses, they do it differently. So someone in Multnomah County, they might only handle family law matters. But I think it's a pretty predominant experience for judges to go from one thing to the other. So there's always this crush of work. So you get done with one thing and then you're into the next thing. It's not often that you get done with one thing and then you have your afternoon to work at your desk or something like that and get caught up. That doesn't happen a lot. What that means is before I go into a proceeding, I just try to take a breath and center myself and shed whatever I had just got done doing and shed whatever is pressuring me to hurry up to get done so I can get to the thing that I have to get on my desk that has to be out because these people have been waiting, and just take the breath and then enter the session, whether it's walking into court like it was pre-COVID or now it's enter the session through the computer, and then introduce the parties, the case, and explain why we are there. This is especially important if people are self-represented, but I do it as well when there's lawyers, because I'm not confident necessarily that the lawyers have explained what's going to happen. And even if they have, I want the litigants or the people in front of me to understand that this is what I think we're here for, and here's what the issues are. So, for instance, in a custody case, I always ask my clerk to provide, if we're in court, people with a short list of the factors that the legislature has directed me to consider in making my custody decision. Because sometimes people come in with all kinds of ideas about what is going to be the basis of my decision as a judge. And I actually have guidelines from the legislature about what I need to look at. That's just an example. So I'll explain to them what the issue is that I'm going to be looking at, especially if they're self-represented, because they're going to be the people that are providing me with their evidence. And I explain how the procedure is going to work, who goes first, who goes second, when you get your chance to talk. I assure everyone they're going to have a chance to tell their side of the story, because that's the basic orientation for every case. And that takes time. I give people an opportunity to ask questions. Do you have any questions about how we're going to proceed, for instance? And then we hear the evidence. And then when I'm getting ready to make the decision, if I take it under advisement, which means I'm not making my decision right then, I always try to write an opinion that explains my decision so they understand it. Not just who won or who lost, but why. I also always explain to people that any decision I make, almost any decision, that's not true in small claims cases, but any decision I make, there is a way to correct that decision by an appeal. And that's also part of procedural fairness. And the research shows that it's important for people to understand that trial judges don't just have unlimited authority to do whatever a trial judge wants. There is actually an appellate process, a correctable process that would correct errors. So I explain to people about that and listen. And if it's appropriate, ask questions that tell them that I am hearing what they are saying. So that's my general approach. And that would be how it would look probably in any proceeding. If you came into my courtroom, it wouldn't matter what the case is, but those basics would be there.
Judge Waller, would you like to add anything to that?
I agree that collecting oneself before going on the bench is really important. Making sure that others in the courtroom, my staff, others throughout the courthouse also have an understanding. We've done a fair number of trainings for all of our staff on procedural justice and implicit bias and trauma-informed practice, because we know that the majority of cases do not get resolved in a courtroom by a judge. They're by a clerk at a public customer counter. I try to listen to myself every once in a while, which I don't like doing, but to make sure that what I'm doing on the bench is what I believe that I intend to do on the bench in terms of how I'm interacting with people. And I know that's one of the techniques that some of the judicial leaders in procedural justice have suggested. Judges watching other judges, listening to themselves so that you're sure that you are actually doing what you intend to do in terms of being understandable, slowing down enough. Years ago, Justice Gillette, when I first came onto the bench, shared with me an injunction from an Egyptian pharaoh that I keep at my desk. Not everything that one prays for can be granted, but a good hearing can ease the heart. That's a great sentiment for just remembering that somebody's going to get what they want. Somebody may not get what they want. Nobody may get what they want, but if the hearing is done correctly, it will really go a long way. And then my second quote that I keep close by is a quote from Maya Angelou. I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. And I think that both of those, in terms of procedural justice, are really basic to making sure that we understand that how somebody feels as they leave the courtroom is going to have a big impact on how they view the justice system.
I think that also, and I think you'd probably agree with me, Judge Waller, since I think I know you a little bit, is that I try to convey in whatever way seems appropriate in the particular case that I care about people and I care about the people that are in front of me. I try to connect with them on a human level. And there's different ways that you can do that depending on what the situation is. I've had a case where in rendering my decision, I talked about the difficulties of something I'm familiar with because of my work as a drug court judge. And it just showed that I had a human connection. I care about everyone that appears in front of me. I don't know how it comes out in the research, but I do think that at least in my experience, that people have told me that they appreciate my care, my expression of my care. And that is very gratifying to me because I think that when we talk about procedural fairness, what we're really talking about is a human-centered judicial system that really understands that the people that are using our judicial system, they're bringing to us all kinds of human problems, and they're experiencing just various levels of brokenness, whether it's a broken marriage or a broken dream of a business partnership, or it's the result of some brokenness that results in someone being charged with a crime and now is facing prison. And I think if we ignore the human aspect of what brings people to us and we just look at it like scientists in the sense of, okay, what's the chemistry of this? Let's figure out what the law is and then in a sterile way apply the law, and we don't touch the human boundaries by telling people, I'm sorry you're going through this, or I understand this is so hard, or to parents that are being divorced and fighting over their children, I understand how difficult it is to move forward and you've got all this disappointment in your life because you got married and you had a child and you thought you would be together and you're not. And that hurts. Just recognizing the people that they are to the best that you can figure out who they are in the limited time that you have. I think that is also a really important component of procedural justice. And I'd like also to just say that, as I said earlier, the procedural justice it's not just something judges do, it's our clerks, it's all the people in the courthouse that serve the public. And I see that the best of those folks are the people that do similar things. They reach out on a human level. And so they might not even have the training. Judge Waller has said that they've trained some of their staff. I don't know how many courts have been trained across the board on issues of procedural fairness. I think they've been trained on some components of it. But it's also just this innate willingness and ability to connect. You see someone crying, they don't know where they're going to go. What's going on in the courthouse? It's huge. They're under stress. They don't know what courtroom they're supposed to be in. And somebody from the court staff goes up to them and puts a hand on their arm and says, "Can I help you?" That's procedural justice as well.
Judge Chanti, that's beautiful and so true. It makes me pause, though, and think about the type of cases that sometimes judges, but also lawyers and court staff hear, and the vicarious trauma that you must experience, and then going from case to case and trying to take that breath in between. And how I'd imagine on some days it would make it a little bit harder to take that breath in between and really be able to center yourself in the humanity of it. I could see where that would be difficult some days.
There are days when it's very hard. Yesterday was my mental health court day, and so all day there are moments of joy when, of course, we want to share in when people have made a breakthrough and they're doing well and they're getting their life in order. And then there are moments of absolute despair. I had somebody who showed up in my courtroom yesterday begging me to take him into custody because he's afraid, he's living on the street, he's not on his medication. And of course, there was no basis to take him into custody, so I couldn't. But I also, that despair of thinking that's the only place where I'm going to be safe is if I can get into custody is such a statement about kind of the state of our society. It's heartbreaking. And so there are many days like that where the stories that you're hearing of people that we can solve the problem maybe in front of us, sometimes not though. Especially in the areas of behavioral health when we don't have the resources in our community that we really need in order to be able to provide somebody with the safety, support, and treatment that they need, it can be extremely difficult. And to talk about procedural fairness, to me, one aspect of procedural fairness is that we're actually able to follow through on what we say we're going to do. And so in accepting people into mental health court and then not having the resources to really provide them what they need and the support that they need does not feel consistent with the principles of procedural justice because we've made a commitment and then sometimes they're not able to follow through in the way that we should. We try, and I know everyone's trying, but I think that sometimes we know that the investments in community mental health from decades ago when they closed the large institutions has not been at the level that it should have been in order to fully meet the needs of those in our communities with behavioral health issues. And I think that, along with, there's still a lot of stigma related to being mentally ill, the lack of resources, all of that adds up to sometimes we're not able to do what we would like to do, what we've said we would do in terms of providing people the options they need for being healthy and mentally well in the community.
I was thinking about when you were talking about stigma, Judge Waller, that we even have the stigma of folks who are experiencing a behavioral health condition and they're also within the criminal justice system. How we have that additional burden sometimes in trying to get folks into services because they are involved in the criminal justice system. And so it's stigma on top of stigma, which it can be so frustrating.
It is. There are people who are in the criminal justice system who nobody wants to help. We hear various too acute, too potentially violent, and yet these are all people from our communities who need support and help. We always hope that we'll be able to successfully deflect, when appropriate, people from the criminal justice system. But when they're there, we know that we need to have the resources and access to resources that they need. And I would agree that people involved with mental health disorders who are in criminal justice involved are the bottom sometimes of the pile of who's going to get accepted into whether it's housing or supportive services. And that's incredibly difficult then to try to get people on the right track.
Thank you for joining us for part 1 of a 2-part series with Judge Chanti and Judge Waller. Please join us next time for the continuation of our conversation. The Center Collaborative is a production of the Oregon Center on Behavioral Health and Justice Integration, a specialized division of Greater Oregon Behavioral Health Incorporated. It is produced by me, Chris Thomas, with production assistance from Patrick Kennedy. Music by Patrick Mulvihill and Patrick Kennedy. Subscribe to the Center Perspective using your favorite app. To learn more about criminal justice and behavioral health in Oregon, visit the Center's website at ocbhji.org. You can also find us on Facebook. We'd love to hear from you. Please reach out to us. Join us next time as we chat with the experts about programs and partnerships at work within this complex and yet compelling field.